Yes. Okay, those photocopiers there in front, please. People, come, move aside. Okay, the court has started. Sir, I'm talking to you. Okay? The court has started, so get out of the line of sight and just do your job on the side, okay? Are we ready? Thank you, Mr. Wapiri.
Comply with the...
Yeah, Mr. Wapiri, just do the job and then let's get on with it.
There is no guarantee that it will be accepted. There you go.
So,
But I did not understand of that.
okay, fair enough. But then you listen to it and then if you don't agree with it, then you don't accept it.
That's right.
Good. So next time, please, guys, come prepared. Okay.
Yes, it may Martini please advise you to just decide on
You see, why are we not prepared? Okay. Notice it's not your normal stuff. Okay. Fair enough.
There's a lot of negotiation and
Good, no, fair enough. And I presume you had a busy day yesterday.
understand.
Can you come and give this search?
Thank you, Mr. Polyger. You can put appearances on record and put the charges. Yes. Are we ready?
Thank you very much. State referred Honorable Court to case number SC 126/26, States versus Bellarmine Mugabe, accused number 1, and Tobias Matonhodze. Proceedings conducted in Alexandra Regional Court number 2, today the 17th day of April 2026. The court is composed as follows. Presiding officer, Mr. R.J. Bosho, procedural Wapiri, interpreter, Mr. Bemba. If they don't want him, they can continue in English.
Mr. Ouders, what is the language?
English or should?
Both of you? Both?
Yes, Your Honor.
So you both confirm you are proficient in English and that you wish to proceed in English? Okay, Mr. Ouders, as you indicated, you're happy with the arrangement?
Yes, Your Honor.
Okay,
And
thank you.
The lawyer for the accused is Advocate Odes SC, instructed by Mugunya Tennis. The state likes to place on record that the matter is on roll for further investigations today. However, my learned colleagues, they would like to address the Honorable Court as to what is going to happen.
Mr. Ouders,
Yes, Your Honor. Bishop, the matter was postponed for a month to finalize the investigations. In the interim, as has been flashed on record several times, Your Worship, we've been approaching the state to try to secure a Section 105 AP and sentence agreement. We didn't come to an agreement on that basis. So the understanding between the defense and the prosecution that will proceed in terms of Section 112, which will encompass guilty pleas. To be more specific, Your Worship, the accused 1 will plead guilty to counts 6 and 8 as agreed with the state. And accused 2 will plead guilty to counts 1, 2, 3, 4, and 8. Those are the charges that they
State?
Thank you very much for that opportunity. The state is ready to put the charges to the accused.
So you agree with Mr. Taurus?
That's right.
So he is, so as far as I understood from him, so then he is ready with section 112, the statement, and for the pleas on the counts as mentioned.
That's right, correct.
Okay, good, then you can proceed.
To put the charges to the accused persons. Count number 1, that this count is leveled against Tobias Matonhodze, accused number 2. That the accused is guilty of the crime of attempted murder. In that, upon about the 19th of February 2026, Sandhurst, in the regional division of Gauteng, the accused did unlawfully and intentionally attempt to kill.
So this is again, sorry to interrupt,
Accused number 2.
2 only,
Only, yes.
attempted murder.
That's right.
Yes.
Attempted to kill Sipho Mahlangu, a male person, by shooting him with a firearm. Count number 2, that is the defeating or obstructing the course of justice. This charge is leveled against accused number 2, Tobias Matonhodze. That the accused is guilty of the crime of defeating or obstructing the course of justice, in that on the 19th of February 2026, at Sandhurst, in the regional division of Gauteng, the accused did unlawfully and with intent to defeat or obstruct the course of justice, commit an act to with concealing or disposal of a firearm which was used during the shooting of the complainant, Mr. Sipho Mahlangu. Count number 3, that is the charge for possession of a firearm. It's in relation of accused number 2, Tobias Matonhodze. That the accused is guilty of the offense of contravening the provisions of section 3, read with section 1, 103, 117, 120 subsection 1, paragraph 8, section 121, read with section 4 and section 151 of the Fund Control 62,000 as amended, and further read with the provisions of section 51, 2, and part 2 of schedule 2 of the Criminal Law Amendment Act 105 of 1997 as amended, and further read with section 250 of the Criminal Procedure Act 51 of 1977. In that 19th February 2026, at Onia, Sandhurst, Regional Division of Gauteng, the accused did unlawfully have in his possession the following firearm, to wit: the caliber of the firearm is unknown to the prosecutor, without holding a license, permit, or authorization issued in terms of the Act to possess that firearm. Count number 4, still leveled against accused number 2, Tobias Matonhodze. That the accused is guilty of the offense of contravening the provisions of section 90, read with section 1, 103, 117, 120, and all other relevant sections of the Farms Control Act 60 of 2000, and further read with section 250 of the Criminal Law Amendment Act 108 of 1997. In that, on about the 19th of February 2026, at Onia Sandhurst Regional Division of Gauteng, the accused did unlawfully have in his possession ammunition, to wit: 1 spent cartridge and 1 live cartridge, without being the holder of a license, permit, or any dealership license manufacturer, or otherwise authorized to do so. Count number 5.
Bob is not in this court.
The charge is that of pointing of a firearm. This charge is leveled against number 1, accused number 1, Bellarmine Mugabe. That the accused is guilty of the offense of contravening the provisions of section 120 C, para B, read with section 1, 103, 20, subsection 1A, section 121, and Redwood Schedule 4, as well as section 151 of the Farms Control Act 6 of 2000, in that on or about the 11th day of February 2026, at Hyde Park, Regional Division of Gauteng, the accused did unlawfully point anything which is likely to lead to a person to believe that it is a firearm, an antique firearm, or an air gun, to which caliber unknown to the prosecutor. At another person to which rhyme Guvayashe without good reason to do so. Last count, which is count number 6, is in relation to both accused 1 and 2, Bellarmine and Tobias. That the accused are guilty of the offense of contravening section 49(1)(a), Redwood section 1, subsection 1, section 9 through 2, including 25 of the Immigration Act 13 of 2002, further with Redwood section 250 of the Criminal Procedure Act 51 of 1977. In that the accused as foreigners, unlawfully and intentionally, contrary to the provisions of Section 9 of the Act 13 of 2002, entered the Republic of South Africa on a date unknown to the prosecutor and at a place unknown still to the prosecutor. And whereas the accused thereafter, as foreigners, unlawfully and intentionally remained in the Republic of South Africa in contravention of the Immigration Act 13 of 2002, until their arrest on the 19th of February 2026 at Sandhurst Regional Division of Gauteng. Those are the charges leveled against both accused persons. As the court places my hand in the charge sheet.
Mr. Mugabe, did you understand the charges against you? So against number 1, it is count 6 and 5 and 6, the pointing and 49. Mr. Mugabe, so you indicated you understand the charge against you. What do you plead to it? Mr. Matonhodze, did you understand the charges against you? So it's counts 1, 2, 3, 4, and 6. What guilty? Mr. Oris.
Please the court. Your Worship, I confirm the agreement to plead guilty as compiled section 112. So however, Your Worship, in the time that we left to compile the 112s, my learned friend amended the charge sheet. So we have different numbers. That's why Your Worship will note. I referred to counts 6 and 8. He's done those two counts for accused number 5 and 6. But even in relation to count 6, we have a different date and time and person. It was changed in my absence, so I need to amend the two.
Is that right?
Not necessarily intentionally changed, but they can be allowed to
amend it.
Yes.
Hey. Yeah.
The
Anyway,
it's the same, but it's different events, because I was told that that one's not in this court's jurisdiction, and that we compiled it to on a different basis. But I'm happy to amend. It will take me less than 1 minute, Your Worship.
No problem. You can take your time.
To countersign, so that would be in relation to accused number 1. In relation to accused number 2, everything's in order except for the numbering of the last charge. I refer to this count 8.
But nevertheless, I'll give you a minute to quickly
Thank you, Worship.
change it. In the interim, the matter can stand down. We can do postponement or 2.
Thank you, Worship.
Mr. Mapri?
Yes, I have only one postponement.
Okay.
Will afford them
Okay, the matter stands down for a few seconds.
May I borrow the short sheet to get the
Here it is. Thank you, Mr. Otis.
Worship. As previously alluded to, and I'm grateful to Worship, we corrected the 112s. I've written 112 statements on behalf of the accused. Both of their pleas are in accordance with my instructions, as I recorded earlier, and I'm present with my attorney, Bruni. Worship, to this end, I proceed first with accused number 1, Worship.
You're most welcome.
I hand to your Worship the corrected version and signed version of accused number 1's 112 statement. Worship, it said in the Reason Division of Gauteng held at Alexandra Court, case number RC 126/26, the matter between the state and Bellarmine Mugabe, accused 1. Accused 1 statement in terms of section 1122. Add count 5, pointing of anything which is likely to lead a person to believe it is a firearm. I plead guilty to this charge and state further as follows. 1. And you'll see, Your Worship, each of these changes have been initialed by the accused. On or about 11 February 2026 in Hyde Park in the Regional Division of Gauteng, I did not unlawfully point anything which is likely to lead a person to believe that it is a firearm, an antique firearm or an air gun to it, a toy firearm with unknown caliber and another person to it, Brian Yashu. I knew at the time that it was a criminal offence to do so. 2. 3. In a circumstance, I'm guilty of the offence of contravening the provisions of section 120, sub 6, sub B, read with sections 1, 103, 121A, section 121, read with schedule 4, and section 151 of the Firearms Control Act 60 of 2000. The offence of pointing of anything which is likely to lead the person to believe that it is a firearm. B. Add count 8. Entering, remaining in, or departure from the Republic in contravention of section 49 of the Immigration Act 13 of 2002. I plead guilty to this charge and state further as follows. 4. On or about 19 February 2026 in Antonia Sandhurst in the Regional Division of Gauteng South, I, as a foreigner, did unlawfully remain in the Republic of South Africa contrary to the provisions of section 49 of Act 13 of 2002 until my arrest on that day. 5. I knew at the time that it was a criminal offence to do so. 6. In the circumstance, I'm guilty of the offence of contravening the provisions of section 49(1)A, read with sections 1, 9 through 10, including 25 of the Immigration Act 13 of 2002. Further read the section 250 of the Criminal Procedure Act 51 of 1977. 2. At entering the Republic of South Africa and unlawfully in the intention of remaining in the Republic of South Africa until my arrest on 19 February 2026. It's signed at Alexandra on the 17th of April 2026, and there's the accused signature, and he will confirm it as well.
Mr. Mugabe, do you confirm the correctness of a statement on with regard to both these counts? Good. State.
Our state accept the statement by the accused if it comply with the contents of the charge.
Good. Thank you. I will proceed with judgment as when we finish with number 2. Thank you, Mr. Otis. You can proceed with number 2.
I hand you the original to Worship, also signed Worship, and the single amendment of the initial. Worship, it's head in the same manner. In the Regional Division of Gauteng held at Alexandra Court, case number RC 126/26, the matter between the state and Tobias and Mugabe Matonhodze. Accused 2 statement in terms of section 1122. A. Add count 1, attempted murder. I plead guilty to this charge and state further as follows. 1. On or about 19 February 2026 in Antonia Sandhurst in the Regional Division of Gauteng South, I did unlawfully intentionally attempt to kill Sipho Mahlangu, a male person, by shooting with a firearm twice on his back. 2. I knew at the time that it was a criminal offence to do so. 3. In the circumstance, I'm guilty of the offence of attempted murder. B. Add count 2. Defeating or obstructing the course of justice, I plead guilty to this charge and state further as follows. 4. On or about 19 February 2026 in Antonia Sandhurst, the Regional Division of Gauteng, I did unlawfully with intent to defeat or obstruct the course of justice, commit an act by concealing and disposing of a firearm which was used during the shooting of Sipho Mahlangu, which act defeated or obstructed the course of administration of justice. 5. I knew at the time that it was a criminal offence to do so. 6. In the circumstances, I'm guilty of the offence of defeating or obstructing the course of justice. C. Add count 3, possession of a firearm. I plead guilty to this charge and state further as follows. 7. On or about 19 February 2026, in Anthony Sandhurst, the regional division of Gauteng, I did unlawfully have in my possession a firearm, the caliber of which is unknown, without holding a license, permit, or authorization issued in terms of the Firearms Control Act 60 of 2000 to possess that firearm. 8. I knew at the time that it was a criminal offence to do so. 9. In the circumstance, I'm guilty of the offence of contravening the provisions of Section 3, read with Sections 1, 103, 117, 121A, and 121, read with Schedule 4, and Section 151 of the Firearms Control Act 60 of 2000 as amended, and further read with the provisions of Section 51.2 and Part 2 of Schedule 2 of the Criminal Law Amendment Act 105 of 1997 as amended, and further read with Section 250 of the Criminal Procedure Act 51 of 1977, possession of a firearm. D. Add count 4, possession of ammunition. I plead guilty to this charge and state further as follows. 10. On or about 19 February 2026, in Anthony Sandhurst in the regional division of Gauteng, I did unlawfully have in my possession ammunition to a one-time spent cartridge and one-time live cartridge without being the holder of 1. A license in respect of a firearm capable of discharging that ammunition. 2. A permit to possess ammunition. 3. A dealer's license, manufacturer's license, gunsmith's license, import, export, or in-transit permit, or transporter's permit issued in terms of Firearms Control Act 60 of 2000, was otherwise authorized to do so. 11. I knew at the time that it was a criminal offence to do so. 12. In the circumstances, I'm guilty of the offence of contravening the provisions of Section 19, read with Sections 1, 103, 117, 121A, Section 121, read with Schedule 4, and Section 151 of the Firearms Control Act 60 of 2000 as amended, and further read with the provisions of Section 250 of the Criminal Procedure Act 51 of 1977, possession of ammunition. E. Add count, it's amended to 6 and initials. Entering, remaining in, or departure from the Republic in contravention of Section 49 of the Immigration Act 13 of 2002. I plead guilty to this charge and state further as follows. On or about 19 February 2026, in Alexandra Magistrates in the regional division of Gauteng South, I, as a foreigner, did unlawfully remain in the Republic of South Africa, contrary to the provisions of Section 49 of Act 13 of 2002, until my arrest on that day. 14. I knew at the time that it was a criminal offence to do so. 15. In the circumstances, I'm guilty of the offence of contravening the provisions of Section 49(1)A, read in Sections 1, 1, 9 through to and including 25 of the Immigration Act 13 of 2002, further read with Section 250 of the Criminal Procedure Act 51 of 1977, to wit, entering the Republic of South Africa and unlawfully and intentionally remaining in the Republic of South Africa until my arrest on 19 February 2026. This document signed at Alexandra on the 17th of April 2026, and it bears accused number 2's name and signature. They need to hand it up and will confirm it.
Mr. Matonhodze, did you understand that statement? And do you confirm it as correct? State.
Accept the statement by him. It is in line with the contents of the docket.
The court then proceeds with judgment extempore. Mr. Mugabe, I see both of you are Mugabe, but the one got a name Mugabe and the other one is surname Mugabe. Is that right? Relationship. Pardon? Okay. Good. As far as the plea is concerned, the court is satisfied and convinced that you are indeed guilty, as pleaded. Number 1, you are accordingly convicted as far as counts 5 and 6 are concerned. Number 2, you are convicted as far as counts 1, 2, 3, 4 and 6 are concerned. Good. Previous convictions?
On state prove no previous conviction against both accused, and I'm request the court to analyze this matter today, if it pleases the honorable court.
Yes, Mr. Oudis.
As the court is, Your Worship, if I may deal with the personal circumstances of the
Yes.
He's an adult now, currently aged 28 years old. He is not married. He has no previous convictions. He's never been prosecuted on any offence that resulted in any conviction. He has no other outstanding matters. His permanent residence and where he lives is in Borodale Brook, Harare, Zimbabwe, where he has lived his whole life except for a brief period when he studied in South Africa. He studied in South Africa and completed a course in business administration, majoring in finance at Regina's Business School in Sandton. He completed these studies, Your Worship, in 2002.
And then he was legal.
Yes, Your Worship.
Okay.
Subsequent that he left and then he came back and then he overstayed. He came back to South Africa. If I can just get the date. In September 2025, Your Worship, and then remained in South Africa beyond
The permit.
as Your Worship pleases. So, Your Worship, he completed his studies in South Africa in 2020. He has a farming business in Zimbabwe where he farms in cattle, and he earns between $10,000, that's US dollars, and between $8,000 and $10,000 per month. He has no children, Your Worship, and has never been married. He has a medical condition. He suffers from anemia, Your Worship, and he has an astigmatism, which he receives medication. He has done charity work, Your Worship, in that he supports an orphanage and a school for underprivileged children in Zimbabwe. In his farming business, Your Worship, he employs 65 people. Your Worship, he is in a position to pay a fine. If one has regard to the offences on which he was convicted, Your Worship, there's one of pointing a firearm, there was no injuries or damage to anything.
With regard to him, that's the toy gun.
Yes, Your Worship.
That was accepted by the state.
Yes, Your Worship.
Yes.
Secondly, Your Worship, the remaining in South Africa is administrative. I don't put it down or say that it's not an offence. He's accepted guilt for it, Your Worship, and pleaded guilty, which is a sign of remorse in respect of both of the offences. So, Your Worship, I've asked the court to look upon his case with mercy and to consider the imposition of a non-custodial sentence, a suspended sentence, and he is in a position to pay a fine. He also undertakes, Your Worship, to pay for his own deportation back to Zimbabwe and the costs incurred in relation to that as well, over and above a monetary fine and the suspended sentence. Your Worship, may I deal with accused number 2 and then I'll deal with the cases that I rely upon in support of my submission.
Fair enough.
Accused number 2, Your Worship, is older, as Your Worship heard, they're cousins. Accused number 2 is 32 years old, also an adult now, Your Worship, who is not married and has no children. Similarly, Your Worship, a first offender who has never been prosecuted or convicted and has no other outstanding cases. Your Worship, he lives permanently at Plot A, Norton, in Mazoe, Zimbabwe, where he has lived his whole life. He has a cattle farming business, Your Worship, where he earns between $2,000 and $5,000 per month. He's still completing a degree, Your Worship, in international relations. In his farming business, he employs approximately...
Sorry, where is he completing this degree?
In Zimbabwe, Your Worship.
Okay.
He doesn't, so we're not
Yes.
asking an extension from the court, Your Worship. At the farming business, Your Worship, he employs 30 people on a permanent basis. I just need one instruction. He came to South Africa, Your Worship, in 2024. So he's been here longer than the other accused. But similarly, Your Worship, he'd been here previously legally and there was no issue. Your Worship, there are a few cases that are in point on this one, Your Worship. The one, Your Worship, will know very well because I know Your Worship follows the rugby, and that was
I follow the what?
the rugby, Your Worship.
Oh, yeah.
The case of Tobias, where the rugby player was stopped by a traffic officer and they got into an altercation. He was drunk and he killed the traffic officer and he paid compensation to the traffic officer's family.
Who's the rugby player?
His real name, Your Worship, is Jacobus Stefanus Brew, but he was known in
Oh,
the
Bias.
Bias,
Yeah.
Your Worship uses. So we have that is one possible precedent.
Yeah, but he wasn't illegal.
No, Your Worship.
Yeah?
None of them were illegal, Your Worship.
Okay.
The other one that we had, Your Worship.
So you got case law there for illegals.
No, Your Worship.
Okay?
We Very unusual, Your Worship, that illegal people are convicted of this and plead guilty with these type of offences.
No, they usually plead guilty
But not with other offences.
with the immigration. Yes?
We have another judgment, Your Worship, of the Eastern Cape High Court in the Port St. John Circuit Court by the Honourable Mr. Justice Brooks. It's the State versus Nolalin Zima and Dila Malundani over copper.
Sorry, Mr. Otis, but the case of BS Road, there was restorative justice
Yes, Your Worship.
applied.
Yes, Your Worship. In this case, the complainant has been compensated and had already, prior to the incident, Your Worship, started a business that was financed by accused number 1.
So both so all the complainants had been compensated.
Well, the one where there was with the toy gun incident, there was no compensation that I'm aware of, Your Worship. But the person that was injured by accused number 2 has been compensated, Your Worship.
Okay.
If one looks at the Malundana case, Your Worship, where Justice Brooks was dealing with,
So, but are there no damages for the one who was just pointed?
I'm unaware of any request to
Okay.
it would have to have come from our learned friend. But
Okay.
if there's a need to do so, there's no difficulty on the accused side, as I'm going to address, Your Worship, in due course. But in this Malundana case, Your Worship, it involved a security guard who was in his 60s, had no previous convictions, had a, it seems like a homemade firearm that was illegal in his possession.
But also a legal person.
No, he wasn't illegal, he was legal.
Yeah.
So what happened there was he was a security guard at the school. He was alerted to a noise in the media room. He went there and he saw the people running away, shots at those people. He killed a 13-year-old and he injured another 13-year-old.
But that was accidentally.
No, he was pursuing them. So he was,
Okay.
he was convicted of murder and attempted murder.
Yes.
So in that matter, Justice Brooks said and he paid compensation in that he paid for the funeral of the deceased and made peace with the family of the injured of the injured child. And in that matter, the charges were taken together and not taken together, suspended sentences on all the charges, which included murder and attempted murder, Your Worship. That's the judgment that I've been to. In this instance, Your Worship, the accused have been in custody for more than 3 months since their arrest, and they remained in custody. And what they have done, Your Worship, is they also, through their family, approached, and with the permission of the investigating officers and the attorneys, there was an approach to the victim who was compensated and has made him as deposed to a statement to that effect that my learned friend is aware of. That there's no issue there that he would be satisfied with a non-custodial sentence. Reparations were made. Should this court order further reparations, both of the accused would be in a position to honour such an order. There's no problem, Your Worship. Similarly, should this court be inclined to impose a fine, albeit even a hefty fine, Your Worship, both accused are in a position to pay. They have the money set aside, and the arrangement could be made. And it's not on a never basis or a long-term basis, Your Worship. The monies can be paid over this weekend by Monday, and everything is put into place, including the purchasing of their return tickets to Zimbabwe, Your Worship, should the court be inclined to go with a sentence of that nature. I would respectfully submit, Your Worship, that the correct sentence here, an appropriate sentence, because Your Worship has a myriad of possible sentences, but the appropriate sentence here would be a suspended sentence, which would then hang over their heads as a warning so that they don't do this again. They're both relatively young, they ought to be punished, Your Worship, but I do believe that if the court imposes a suspended sentence, it will serve as a warning to them that if they cross swords with the law again, they're going to have a problem. So it will hang like the draconian sword above their necks. And I would add to that, Your Worship, a monetary fine and compensation to the respective complainants should they be requiring same or in terms of the criminal procedure against section 360 makes provision for compensation and or restitution and in the form of a buntu justice, Your Worship. I have no further address on this, Your Worship, which
Take.
We'll be proceeding by calling Colonel Raj to the witness stand.
Thank you.
Your Worship, since there is no space that side, maybe
No. They make space.
Okay.
They can't. If you call a witness there, they must make space.
So we don't have a witness statement from the criminal, but it's in sentence, so I don't have an issue with it.
No problem.
As he testifies.
You're welcome to stand on the other side. But anyway, I'm happy to, with the cameras here. Colonel, you can just enter the witness dock there. You're most welcome to take positions on the other side. You're most welcome. Colonel, your full names? You swear that the evidence you will now give will be the truth, the whole truth, and nothing but the truth. Put up your right hand, say so help me God.
How long have you been within SABC?
I've been within SABC for 33 years.
Which unit do you work for?
Currently working with the Provincial Investigation Council.
And what is your position in that unit?
I'm acting as a commander for the Provincial Investigation Unit.
You were sitting in court during the presentation of the mitigating factors by the defense. You had them?
Yes, I do get it.
There is an issue which they have actually addressed the court that the investigator had facilitated the remuneration of the victim, Mr. Sekomatam. Did you hear that point?
Yes, I heard that point.
What's your comment on that?
At no stage did I interview any complainant in this case or been in touch with any complainant in this case.
So anyway, the remuneration aspect, Colonel, did you contact the complainants? Were they remunerated, or do you need time to follow up on that?
I have no idea on that.
So you need time to follow up on that.
Yes, sir.
Okay. So that's basically the evidence.
Your Worship, can I continue with him, even though
Yeah.
the honorable court may still be postponed for that purpose? The impact of the offense, how serious, according to your own knowledge and experience within SABC, was this attempted murder?
Your Worship,
That is now accused number 2.
That's right.
Yes.
Your Worship, accused number 2, firstly, is undocumented.
He? You must speak up.
Your Worship, his passport is not valid at this time.
Yeah. You were asked about the offense.
Okay. Based on the offense,
So the injuries, etc.
based, Your Worship, on the attempted murder. Your Worship, as you have just heard, a firearm was used to commit this crime. The state,
Illegal or a legal fire?
an illegal firearm.
Yeah.
We are still yet looking for this firearm. And Your Worship, both the accused were there at that time when the firearm was fired and injured the victim. The accused shows no remorse in assisting the police in any way to point out the firearm. They know where the firearm is. That firearm is...
Mr. Otis, while that point is going, comment.
So he's referring to both of the accused who have been guilty of an offense.
No, where's the firearm? The whereabouts of the firearm?
Because I haven't received instructions on it.
Okay, you want to, but anyway, I'm going to postpone it already for the reasons mentioned, so, and for instructions. Good.
Your Worship, may I just add on there? At this stage, I have a tracking team available. Should they change their mind, it can be communicated through their attorneys, and we are available to act.
No, that's fair enough. You heard me. I asked the defense.
Noted.
Good.
Your Worship, on that score, the state is going to make an request for postponement of this matter in order for the kennel to follow up on 2 issues that have been raised, the issue of compensation and the possibility to try and locate the firearm that was used. This is my application.
Mr. Otis, those instructions will be followed up today?
Yes, Your Worship. Your Worship, as to availability, I'm only available on Friday next week, Your Worship, with my attorney.
And Friday next week is good with us. We will make space for it. You can see we got a big crowd here. Yes, or a big engine. Yes. Friday next week.
24 of April 2026.
Colonel, 24 April. So you can just hang around for the information. Let's make it half an hour. Let's do this. Half an hour, fair enough. Good, and then 24 April for the required information on the complainant. Good, 24 April, Colonel, you want for court both the accused in custody.
There's a main inquiry before we postpone.
Yes.
Is there any other information to Colonel once that we don't find ourselves postponing?
No, we got those two aspects. Am I right? Okay. (24 April) for the reasons mentioned, both in custody. A short adjournment for the just everybody to adjourn peacefully. Am I right?
Can you get them down?
24 April for the reason mentioned, 5 minutes. Thank you everybody. Court adjourns.
All right, we got out there.